again, you're potentially liable for damages, for money damages, because we have these different employment laws that we have to deal with, and we call it, and we'll talk about this later, but we actually call it alphabet soup. But there's so many protected areas we have to be aware of where there can be potential liability when we hire, fire, discipline, and those types of things. So those can fall under race, color, religion, sex, including pregnancy, national origin, age discrimination, and also disability. So again, these are some areas that we're going to basically cover today. Now, the big federal law that we're going to talk about, getting in real in depth in, is the Title VII of the Civil Rights Act of 1964. So Wayne's going to talk very in depth about this, but this is kind of the big law where we have a lot of our litigation over. So again, it's Title VII of the Civil Rights Act of 1964, and it prohibits any kind of employment discrimination based on those protected areas. So this applies. Now, this law does, with smaller employers, it doesn't apply, very small employers, but typically anybody that has 15 or more employees and state and local governments, this law does apply. So anyway, harassment based on, again, these protected areas can form a basis for a substantial claim. So again, we want to give you, again, a basic understanding, if you don't already, of Title VII. So, and there's some, also under, we have some of the employment laws that are actually enforced by the Equal Employment Opportunity Commission, but outside of that, there's also a federal statute called 42 U.S. Code Section 1983. And under that federal statute, it's an avenue used to enforce constitutional rights. So since we're the government, we can potentially violate constitutional rights. And this can actually happen in the employment arena, and individual officials or employees can be sued individually if they're, and it doesn't mean you don't have insurance coverage for it, but what it means is that you may be sued individually, and the only way the county could be brought into it if there's some unconstitutional policy or customer practice of condoning constitutional violations. So anyway, the high risks really are, and I'm just speaking historically from what we deal with, is that terminating an employee, laying off an employee, or constructively discharging an employee, that's where you're typically running into a lot of your potential claims and litigation as in those particular areas. So those are what we call the high risk areas. So when you get into those situations, you want to make sure you're getting some advice of legal counsel or somebody that's versed in employment law to help you deal with those types of situations. So again, you're more exposed to potential claims and lawsuits. There could be more damages, and again, an increased opportunity for extraordinary charges, or damages, excuse me. So anyway, with that being said, that's my part. I'm the warm-up band, and here's the main event. So turn it over to Wayne.
Thanks, and I'm going to put on the microphone.
Yeah, that's a good idea. That's a good clip on your book.
Mm-hmm. Thank you. All right, good morning. Let's see. Get that up there. I'm glad to be here. This is a presentation that we do all around the state for any county or city that would like to have their supervisors learn some of these principles that we're going to talk about today. Because I think it's important for supervisors in particular, and all of you, to understand some of these principles and bring them back into the workplace for a couple reasons. And you're going to be bored by my saying this by the end of the presentation. One is, I think supervisors have a tendency to look away when they see something that is potentially a legal issue that's arising in their environment. And there's a couple instances that we'll talk about where actually quick action by an employer is extremely important. The second thing is, I think supervisors in particular have a duty to set a tone, an example for employees in the workplace, and that tone and example, if it's followed by their employees, can reduce your risk of employment liability. I do want to say I'm glad to have Kent Irwin sitting in the back and going after me today, so that after I'm done, Kent can correct everything that I've said, or at least anything that I've said wrong. Kent is a valued expert in these areas as well, especially in the area of putting together employee handbooks, and in wage and hour, which I think, Kent, that's what you're going to be talking about, is wage and hour specifically. So I may skip through some of my wage and hour stuff knowing that Kent's going to be covering that. So as Mark said, there are multiple sources of employer liability. U.S. constitutional rights. Why are U.S. constitutional rights important? Well, that's because as government, our employees are citizens, and they have constitutional rights just like any other citizen does. These constitutional rights don't apply to private employers. So if you've got a Magnavox plant or a Westinghouse plant in your county, they don't have to give constitutional or honor constitutional rights of their employees, but we do because we're government. Second, because private employers need to be told what to do, apparently, Congress has passed these federal discrimination statutes that we'll talk about, 5 or 6 of those, that apply to us as well as government. Uh-oh. Oh, that button's too close. Okay. We will talk a little bit about Indiana statutes that our General Assembly has passed that affect the employment relationship and our employees' rights. We will talk a very little bit about Indiana tort claims that an employee can bring. And we will probably not talk very much about, but I want you to be aware that if you have any kind of a contractual relationship with your employees, either a separate contract with one employee or a union agreement with a group of employees, then those give rise to a completely different set of rights, potentially, by your employees. Now, this is a little bit wonky in terms of the legal principles I'm going to be talking about, but that's the way we framed this presentation. I don't expect you to walk out here today with thinking, well, I can go take one more class and I'll get a law degree. However, I think it's a good idea for you to know what the background is in terms of these legal principles so that then we can identify issues that are coming up in our cities, in our towns, and in our counties that could potentially lead to exposure. Another thing I want to say is that this PowerPoint, I think, Mark, we prepared it for cities. Yes. But anytime you see the word city or town in here, that also applies to counties. So I just want you to know that we haven't prepared 2 separate ones for counties. And actually, I thought today was a city thing. So, all right, federal constitutional rights. Created by the Bill of Rights, the amendments to the Constitution. They apply to state and local governments, not private employers. And as Mark suggested, they're enforceable through this statute that I'll talk about in a few minutes that we refer to as Section 1983. So I want to talk about some of the rights, not all of the rights in all 10 amendments, but the ones that most particularly apply to public employees. The First Amendment has actually like 5 different rights in it, and many of them do apply to public employment. The first one is the right to free speech. Free speech. Well, how does a public employee have a right to free speech? Any employee has the right to speak out under the First Amendment on any matter of public concern without being concerned about then being retaliated against for having spoken out on that matter of public concern. Speaking out, how does that come up? A letter to the editor? A private letter to somebody criticizing government, perhaps? What's a public concern? Well, a public concern is something that concerns the public in general. If I write a letter to the editor and say, I think I should have gotten a pay raise last year, and I earned that pay raise, and I think that my boss is being mean to me by not giving me that pay raise, that's probably not a matter of public concern. If I write a letter to the editor and say, I think the county council should have passed a budget that included a larger budget for my department, because my department does important things for county government, that's a matter of public concern. And in that situation, that employee is exercising a right under the First Amendment, and we cannot then retaliate against him or her by not giving them a promotion, by not hiring a person who's written those kinds of letters, etc. There are 2 exceptions that apply. One is that speech that's required by your job is not protected. This arose in the context of a case where an employee was writing a memo that was part of his job, and in that memo he made statements, and he was then retaliated against for making those statements or punished. And the U.S. Supreme Court held that if the speech is required by your job, it's not covered by the First Amendment. The second example is that there are certain employees in government, and we'll talk a little bit about this on the next slide, who are protected because they are policy-making employees. And they also do not have the same First Amendment protection that most other folks have. So if you are in a situation where an employee is engaged in speech, it may not always be protected because there's some speech that might be damaging to government. So here's an example of the case where that came up. The day after President Reagan was shot by John Hinckley, and I don't see anybody here who was around then. Probably you're all too young to remember that. I remember it, though. There was a sheriff's dispatcher in Texas, county dispatcher, and she was overheard to say, "I wish they'd gotten him," or words to that effect. So the sheriff didn't like that, and he terminated her employment, and she sued for violation of her First Amendment right. And the U.S. Supreme Court held that that speech was potentially protected by the First Amendment because she was expressing a political view. However, the court, it sent it back to the lower courts to do this balancing test, to give the sheriff an opportunity to prove that that speech was so disruptive to the operation of the sheriff's department that it interfered with the operation of government. That's a hard test to meet, but it is a test that's possible to meet if you think someone is engaging in speech that is potentially disruptive of governmental operations. Not a test to apply on the fly. If you think you're in that situation, it's a test where you need to then go to your county attorney and talk about, is this a situation where this speech, where terminating this person or punishing them for this speech could potentially be defended in court on a First Amendment claim. Free political association is another right that's protected by the First Amendment. The word politics doesn't appear in the First Amendment, but the Supreme Court has held that the right to free association is covered by the First Amendment. So what does this mean? It means that somebody's politics, supporting a particular candidate, supporting a particular party, even supporting somebody who's within a faction, a different faction of the same party, is protected conduct under the First Amendment and cannot be something on which you make hiring decisions, firing decisions, disciplinary decisions, etc. This applies in an interesting case that came out a couple years ago, even if you're mistaken about this employee's political beliefs. How did that happen? Well, we had a situation, I think it was in New Jersey, where a police officer was seen to go to a headquarters of a political opponent of the mayor or somebody and pick up a yard sign and put it in his car and drive away. Well, at that point, it was assumed that he was supporting the opponent, and he ended up being retaliated against in some way. I don't remember whether he was fired or demoted. So he sued and said, that violated my First Amendment rights. Turns out, he wasn't supporting the other guy. He was picking up the yard sign for his mom. So the city said, we couldn't have been retaliating against him for his politics because we were wrong about his politics. Supreme Court says, if you were motivated by political retaliation, even if you were wrong about that person's political stance, that still is a violation of his First Amendment rights. And here's where the important exception comes up. The Supreme Court has said that certain employees in government, appointees really, are so important to policy making for an elected official that those employees do not have this First Amendment right of political association. Put another way, there are certain employees for whom it's important for an elected official to be able to say, this person is politically aligned with me, and therefore I can choose them based on politics, based on political support. It is very, very difficult sometimes to determine when the line has been crossed between somebody who is or is not a policy-making employee. In county government, as sort of a shorthand, we assume that anybody who is a chief deputy of an elected office holder is a policymaker. Sometimes we have argued that anybody who is a deputy, who is a duly appointed deputy, is a policymaker. That argument doesn't always fly, but it is a good point if you're an elected policymaker to go ahead and go through what you think might be sort of a pro forma exercise of formally swearing in anybody in your office who has that position of deputy. Because some courts have said that anybody who's a deputy, which under Indiana law means anybody who can exercise the functions of your office when you're not there, is a policy-making employee. Still on the First Amendment, freedom of religion. Freedom of religion. This prohibits discriminating against any employee based on his or her religious practices or beliefs. We don't get many First Amendment cases on this because this is also covered by Title VII, which we'll talk about in a few minutes. However, it does mean that our employees have the right to believe whatever they want to believe, including if they don't believe, if they don't want to believe in any religion at all. We cannot discriminate against them based on that. Religion-neutral policies are okay if they're justified by a strong governmental interest. So under this exception, we might say that because we're a 24/7 operation, everybody in this operation has to work at least one weekend, regardless of the fact that your religion requires you to go to services on a particular day of the week. Those are case-by-case situations, and always we need to consider the possibility that someone's religious beliefs can be accommodated without it being an undue burden on government. But that is one possible exception to this particular right. Then, in addition to freedom of religion, the Constitution requires that government not be establishing one religion as being a favorite over another religion. So we can't have an endorsement or favoring. I was just talking to my friends from Franklin County who had to deal with this in terms of a Christmas display on the courthouse lawn. And this is the source of those kinds of cases, or Ten Commandments displays, or those. How does this come up in the workplace? Well, someone might say that by having a Christmas party in your office that you are endorsing Christianity as a religion. So we need to be very careful about the possibility that any of our employees might see that as being an establishment of one religion over another. I ran into an example of this. This is many, many years ago, where we were looking through an employee's personnel file and found a job application that had been used by this county, I'm sure for decades. And on this job application, one of the questions was, what church do you attend? Okay. Two problems. Clearly, the county assumes that anybody who's applying for a job attends some kind of a religious institution. Second problem is the word church means church. It doesn't mean synagogue. It doesn't mean mosque. It means a church. So we immediately advised the client. That was not the issue in the case, but we immediately advised the client, revise the job application and take that question off. I think they weren't even aware that it was still on there. You know how that goes. That probably doesn't happen in any of your counties, that a piece of paper like that just gets used year after year after year and nobody looks at it. The Fourth Amendment does have some application in government. The Supreme Court has held that our employees have a limited Fourth Amendment right in their workspaces to personal objects or personal items. So, for example, if you've got a situation where your paperclip count is down, you've noticed that there's fewer paper clips at the end of the day than there were at the beginning of the day. So you think, well, I need to look and see if somebody's been squirreling away these paper clips. Well, you can look in the employees' desks that are owned by the county, in filing cabinets, and other places that are owned by the county. You cannot look without a warrant in an employee's briefcase or purse or some other kind of personal article where that employee has what the Supreme Court believes is an enhanced expectation of privacy. In that case, you need to go to your prosecutor or to your law enforcement folks and say, I've got some cause to believe that paper clips are missing, but we're going to need to get a warrant in order to search this employee's purse or briefcase. And you won't get it, by the way, based on that. Some of my clients run into this issue. They have a department that has lockers where employees are allowed to put stuff during the day. And they give them a lock or a combination. This happens in highway departments. I know it happens in police departments. And the question is, does the employee have a privacy right in that locker? Well, the answer to that question, without completely out of context, is we don't necessarily know. So we have control over this, though, in a couple of ways. One is that we can set forth in writing, given to the employee and signed by the employee, that this locker is county government, It is not a private space, and it's subject to search at any time. And even better, that piece of paper would say, I consent to a search of this locker at any time, signed by employee. That way you're protected against some kind of a Fourth Amendment claim if a drug dog just happens to be walking by and goes nuts when they go by Joe's locker, and you decide we need to look inside Joe's locker and see what's in there. The Fifth Amendment comes up rarely, but it does come up, and I just want you to be aware of it. The Fifth Amendment includes the right against self-incrimination. We see this all the time in the police procedural shows, but how could that come up in the workplace? Well, you've decided that Sally is the one who's been taking the paper clips. She's just got that guilty look on her face. So you call her in and you say, Sally, I need to ask you about the fact that we've been missing paper clips. Well, right away, you're called into a position where the Fifth Amendment might have application. Because if Sally says, I ain't talking, you're not getting any information about paper clips from me, and you say, if you don't tell us what's going on with the paper clips, we're going to fire you, then you have essentially compelled her to testify against herself. At that point, you violated her Fifth Amendment right, and we've got problems. There is a method to overcome this. It happens almost exclusively in the law enforcement context, and it's called a Garrity warning. A Garrity warning is where you can say to the employee, anything you say to us is immune from being used in any criminal prosecution. And therefore, under those circumstances, the employee can then be told, yes, you have to answer these questions. Here's the problem. Nobody in this room has the right to grant that kind of immunity for what can be used in court. Therefore, you can't question that employee unless you have the cooperation of your prosecuting attorney's office and law enforcement in terms of under what circumstances can we require this person to answer questions about potential criminal conduct. I'm not going to talk much about this because it actually, with good employee manuals that we have all around the state, it doesn't come up that much. And plus, almost all of our employees are what we call at-will employees, which means they do not have a property interest in their job. However, there might be circumstances, and if you hear your attorney using words like property interest in their job, then you might need to be concerned that any time you take away that job, either by suspending that person or firing that person, you may be depriving them of that property interest without due process. And due process includes notice and an opportunity to be heard before that person can be terminated. So those kinds of employees have to receive some kind of a pre-termination hearing before they are disciplined. And then a fired employee has a liberty interest in his or her reputation. What does that mean? This comes up too in another context, in the defamation context. But here's what the liberty interest means. The Supreme Court has said that if you fire an employee and you publicly state, we fired this employee because he or she engaged in some unsavory conduct, then you possibly have destroyed that employee's reputation without giving them a chance to respond to that allegation. Due process requires that they have a chance to respond to information that takes away their occupation in that way that destroys their reputation. By the same token, and more often, what we'll have is you'll say something about an employee who's been fired or disciplined, and they might have a cause of action against the county for defamation, for destroying their reputation. And I'll give a piece of advice here that I may repeat later, and that is if you are ever in a situation where you have an employment situation that's brewing and the media are interested, even if the media aren't interested, you need to be careful about what you say and to whom you say it. We've had a case in this state where a juvenile probation officer was accused of, or was suspected of, having sex with some of his juvenile probation subjects. And he was given a lie detector test, and he failed the lie detector test, and some people, including judges, told other people who were not in government that he had failed that lie detector test. Turns out the lie detector test may not have been completely reliable, but the problem is that he was then able to argue that he had been defamed, that is, and his reputation had been permanently damaged by this information leaking out. So the advice is, if you ever have a situation where something of that nature is occurring with one of your employees and that you think you might get media inquiries, and you probably see this happening now more and more, write a statement that has been cleared with your county attorney, and any kind of media inquiry that you get, have that statement read to that person. That accomplishes two things. One is you're confident of what is being said, and the second is it eliminates, you can never eliminate this, but it really reduces the chance that the media will be able to change what you've said in the way that they can when there's just an oral, unrecorded conversation. So strongly advise that you use a written media statement instead of just answering the phone and talking to a reporter about why that employee was fired. The 14th Amendment also includes what the court calls a substantive due process protection. This is a protection against, for all citizens against conduct that would be so intrusive that it shocks the conscience of the judges. As you can imagine, there's lots of ink that's been spilled over what that means, but the bottom line is that if there is shocking conduct in the workplace, it might be a 14th Amendment violation. This comes up in law enforcement with high-speed chases and bodily intrusions. It can come up in the workplace in a sexual harassment case. If there's been a sexual battery, then that might be also pursued as a 14th Amendment substantive due process claim. And then equal protection it protects us against discrimination in the workplace, including any kind of thing. Race, sex, anything that's covered can be the basis for action under the 14th Amendment Equal Protection Clause. And sexual or racial harassment can be pursued, but we'll talk more about that when we get to Title VII. So, why do we need to know all of this? That's because way back in the 1870s, Congress passed this Section 1983. It wasn't called that then, but it's called that now. This was part of the post-Civil War anti-Klan acts that were designed to provide a federal forum for people who couldn't sue in state court because the state courts in the South were still controlled by folks who were against the federal government and weren't honoring the civil rights of African Americans who'd been freed from slavery. So that's your history lesson for today. So for decades, nobody even knew that Section 1983 was on the books. Nobody used it, nobody sued under it. Then all of a sudden in the 60s, it was reinvigorated by the US Supreme Court and now has become a major source of federal litigation. When you hear that somebody is being sued for a civil rights violation in federal court, it is almost always going to include some counts under Section 1983. And why is that? Well, it allows a lawsuit for the violation of any federal constitutional right. So anybody who thinks that their federal constitutional rights have been violated can bring a lawsuit under Section 1983. It permits suit against an individual officer or employee who has violated somebody's civil rights. So it permits a suit against an individual police officer, against an individual supervisor in an office, and it also permits suit against a governmental entity if the violation occurred as a result of a policy, practice, or custom of the governmental entity. The remedies, there is no limit to the damages that you can recover. You may have heard that under the Tort Claims Act, there are caps on damages, but Section 1983 has no cap. You can sue for injunctive relief against the unconstitutional practice, which in the employment contexts include suing to get your job back, or if you've been demoted, to be reinstated to your position. Punitive damages can be awarded against an individual defendant, not against the entity, but against the individual defendant. And really the most important thing from a litigation point of view is that if a prevailing plaintiff, if a plaintiff prevails in one of these lawsuits, then he or she is entitled to recover, in addition to the money that's been recovered as part of the relief or injunctive relief, all of their attorney fees. So if you have an employee who maybe didn't get a promotion and lost $10,000 and goes to court and gets that $10,000 back, we may often find that we're facing an attorney fee bill, if the case has gone all the way through to trial, that's in 6 figures. This is why, if you've ever been in a litigation situation, your attorneys might start talking very early on about whether a claim is subject to being settled. That's not because this $10,000 looks like it's an awful thing. It's because down the road, we may end up looking at a huge attorney fee award at the end of the case. Okay, that's the federal constitutional rights. Then I promised you, let me see how we're doing. Okay, good. Promised you that we talk about some of the alphabet soup of federal anti-discrimination laws that we're also subject to. And these also apply to private employers. So Title VII is the big one. More than 50 years, 53 years old now, signed by President Lyndon Johnson, very much occasioned by the civil rights movement led by Dr. Martin Luther King. This statute very simply, you would not think it's so simple based on some of the litigation, but very simply says that no employee may be discriminated against by an employer on the basis of race, color, national origin, religion, or sex. For many, many, many years, federal courts have said sex, which is the word in the statute, does not include sexual orientation, sexual preference, or gender identity issues. Last April, the 7th Circuit Court of Appeals, which is the Court of Appeals that covers Indiana, Illinois, and Wisconsin, changed that law for us and said, yes, the word sex now does mean sexual orientation. And then since then, a district court has said it also applies to gender identity issues, transgender issues. So you might think then, okay, that's the 7th Circuit. That'll get appealed to the U.S. Supreme Court, and the U.S. Supreme Court will have a chance to consider this for the whole country. Well, the defendant in that case, which was a public entity, by the way, decided not to appeal. So today, the law in our circuit is that the word sex in Title VII includes sexual orientation. So what does this mean for you as a county government? That means that if you do have a situation that arises in your county, regardless of whether you've included sexual orientation in your handbook, regardless of whether you're one of the cities or counties that have passed an ordinance that talks about the rights of gay people, that you are subject to suit under Title VII, and you are obliged under Title VII in the 7th Circuit to not discriminate against people based on sexual orientation. And we'll talk about some of these other areas later, but that's the most important thing I want you to carry away today, is that particular status of the law. A victim under Title VII can bring a lawsuit against the employer for back wages, damages, compensatory damages, including emotional pain and suffering, reinstatement to his or her job or position, and, as with Section 1983, all the attorney fees that the plaintiff's attorney spends in getting to that result. So again, it's a very powerful remedy. The victim must first file a charge with the Equal Employment Opportunity Commission, and they have a working agreement with the Indiana Civil Rights Commission that charges filed in either agency can be paralleled as having been filed in the other. If you get a piece of paper that says, Equal Employment Opportunity Commission investigation, please answer these questions, it will look to you like 100 pieces of paper that come across your desk every day from IDEM, from the EPA, from all kinds of federal agencies. However, it's not. It's a prelude to a lawsuit. So if you see anything like that, please resist the temptation to just answer the questions and send it back in. Please send it to your county attorney, send it to your insurance carrier, and let them know we are now in the prelude to a lawsuit over an employment situation. Now, this is an area of some confusion. Lawyers like to try to clear up confusion, and generally lawyers leave people more confused than when they started, but I'll give this a shot. Title VII does not have the word harassment in it. Nowhere to be found. The word harassment has never been in the text of Title VII. That's because of this distinction that the courts have made. There are two types of discrimination. That's the word that the statute uses, is discriminate. There's disparate treatment, and this is what we think of as being standard garden variety. I treated you differently because you're a woman. I treated you differently because you're black. I treated you differently because you're Muslim, okay? That's disparate treatment, and it can be disparate treatment in any of these areas. Hiring somebody in the first place, how much you pay them, whether you discipline them, whether you promote them, and in the case of religion, whether you accommodate that religion. So that's disparate treatment as a form of discrimination. The second form of discrimination is harassment. This is permitting a work environment that is hostile to the employee based on that employee's characteristic, whether it's race, national origin, religion. And it does not apply only to sex. When people hear the word harassment, the first thing they think of is sex. Especially today, it seems like every day there's a new headline about somebody who has been engaged in some kind of sexually offensive conduct. However, this also applies to race, sex, national origin, or religion. And one of the things I preach to you is to go back and check your employee handbook and make sure that the harassment section includes references to race, sex, national origin, and religion, and is not limited just to sexual harassment. There were some cases that came out in the 90s where the US Supreme Court said having a policy on harassment is a good thing, and a bunch of people then flooded their handbooks with 3- and 4-page sections on harassment. Unfortunately, many of those only referred to sexual harassment. They didn't refer to some of these other types of harassment. So do check that. So in the legal context, harassment is not just one isolated incident. Harassment is conduct that is so severe or pervasive that it changes the terms of employment. And that has to be true for both a reasonable person and for the person who was offended by this conduct. So the legal test is pretty strong in favor of employers. The legal test is, this is not something that's just a one-time pat on the back or some other body part. This is not one joke. This is not one computer screensaver that has offensive stuff on it. There may be some cases where one incident meets this test of being severe or pervasive, because it says severe or pervasive. In that case, and I'll give you an example, there are a couple cases like this of nooses in the workplace that were directed toward African American employees. And the courts have said that probably, if there is a case where one incident can rise to the level of being harassing under Title VII, that's probably it. And there can also be other incidents of perhaps sexual assault that would clearly meet the standard of a single incident. But in most of these cases, what we end up seeing is either a single incident or what we see is a pattern of incidents that occur over a long period of time that are allowed to happen. Under the law, the offensive conduct must be unwelcome. What does that mean? Well, what that means is that it has to be offensive from the individual employee's point of view. That is, that employee has to actually be offended by it. If the employee is engaging in the joking, along with all the other folks, is giving it back as good as the employee gets, and seems to be comfortable with all of that stuff that's going on in the workplace, then technically under the law, it's not harassment. Here's the problem for you as employers. We very frequently run into cases where an employee is terminated and comes back and says, oh, well, I was subject to harassment for this period of time. And then all the other employees say, oh, he or she was going along with it the whole time, they told jokes too. And what we always get is the employees saying, I was really offended by that, but I was just playing along. I was just playing along with everybody else to be part of the team, to be part of the crew. And what that raises then is this fact issue about whether they were really offended by the conduct. The lesson here is that if you see any kind of potentially offensive conduct in your workplace, joking, stereotyping, or any of that kind of conduct, just put a stop to it. don't take a chance on the possibility that employees may then later say, oh, I was offended by it. So what are some examples of harassment? Well, using derogatory language, telling demeaning jokes, posters, computer images, clothing. I think the most extreme example I saw alleged in a case once is that a supervisor had a Confederate flag tattoo on one of his arms. And of course, that put us in the situation of, if that's true, do we have that supervisor wear a bandage over it, or what do we do? Turns out, on further reflection, that this supervisor had a Leonard Skinner album cover on his arm. And I guess Leonard Skinner, I'm not a fan, but I guess Leonard Skinner album covers almost always have some image that has the Confederate flag in it. So we were less worried about that then. Obviously, sexual touching, requests for or suggestions of sex, and men taunting other men for homosexual tendencies. As long as the harassment is based on sex, it doesn't have to be a man harassing a woman. It doesn't have to be white folks harassing black folks. It can be people of the same classification, but they're still harassing based on that particular classification. Yes? Yes, sir?
Excuse me, sir. We don't have women up there.
Where? Up here? Sexual touching.
No, go back to the last place. Men asking another man.
Oh, that one.
Yeah, it didn't say anything about women asking women.
That would also be true. That would also be true. No question about it. Ran out of room on the slide. And as I said, it would be any classification harassing somebody else within that same classification, but based on the classification. So, absolutely true. When is the county liable for this harassment? If a supervisor takes adverse action against a subordinate, classic example being if the supervisor says, I'm not going to give you the promotion unless you have sex with me, and doesn't get the promotion, and the supervisor has the power to do that, then the county is liable for that. Okay, the county is liable for the supervisor's actions. What if coworkers are harassing each other? Then the employer, the county, is liable only if the county was aware of the harassment and failed to take immediate action. Here again is where it's extremely important for supervisors to understand that if they see anything in the workplace that's potentially harassing, that they need to immediately take action to put a stop to it. Supervisors, and I was one, have a tendency to put their head in the sand on stuff like this and hope that it will all work out and hope that these employees will get along with each other next week, but not to take action. That, friends, could be found by a federal court to be a violation of Title VII, because the employer had noticed that something was going on in the workplace and failed to take action. You can tell an employee to use a grievance procedure if you have one in your handbook, and it is important to have one in your handbook, but that does not relieve you of the obligation to investigate and resolve issues that come up in the workplace. Now, the next of the statutes that comes up, and comes up more and more frequently, in the workplace is the Americans with Disabilities Act, or the ADA. This really has two requirements in it. One is that it prohibits discriminating against a person with a disability. Well, let's talk about what a person with a disability is. It's a qualified individual, that is somebody who's qualified to do the job, with or without accommodation, and that is they can perform the essential functions of the job. They have a disability or a record of a disability, or they're regarded as having a disability. Regarded as it. What that means is that even if the person is not disabled, if you consider them to be disabled, if you say, well, this person must be schizophrenic, or this person must be crazy, or whatever, then they can be disabled under the statute even though they're not really disabled. It's how you treat them that determines whether they're disabled. What's a disability? It's a physical or mental impairment that interferes with a substantial life function, or substantially then it's a major life function. For years, when the ADA was first passed, we would get into these legal arguments about what constitutes a major life function and what constitutes substantially interferes. And one of the arguments would be, well, if they're on blood pressure medication, then they don't have this blood pressure problem anymore. That was one of the examples. And then another one is we would talk about what major life functions were, whether this is really interfering. Well, Congress amended the statute in 2001 or so to basically eliminate all those arguments. And now they've listed the major life functions in the statute. And the major life functions include breathing, walking, eating, sleeping, bending, standing, which is a huge source of ADA issues, lifting, working, thinking, reading, concentrating. So basically what this means is that anybody who has any kind of impairment at all is going to be considered to be disabled under the statute. But I'd like to go back to up here. You may think that you don't have any control over whether somebody's disabled, but you do. And it's really important. The essential functions of the job are defined by the employer. We define the essential functions of the job. And where a lot of these cases can be headed off at the pass is to go ahead and do a proper analysis of what those essential functions are and put that in writing. So for example, if it's an essential function of the job to be able to lift 50 pounds, then you can say to the employee who comes in with the doctor's slip and says, can only lift 10 pounds, you can say to that employee, sorry, you can't meet the essential functions of the job. Now that doesn't relieve you of the next slide, which talks about accommodating that issue. But it does give you some control over the process. But another important thing, though, to remember about these job descriptions is that if you have that job description, follow it. Don't make exceptions. Don't give people light duty, because then the next person who comes along is also going to want that light duty. Or give them light duty, but give everybody light duty if you can do that. But this, if you're going to have a job description like this, make sure it's accurate also. I mean, we use the example lightheartedly of the parks employee who comes in with a note and says, I can't lift more than 15 pounds. And the supervisor says, well, sorry, you can't work here anymore. And he says, what about Gramps? Gramps has been here since 1910. He can't lift a feather. Why is he still here? Well, it's because nobody had the heart to say, oh, this job description applies to Gramps. So if you're going to do this and you're going to set up your record properly to defend an ADA claim, you need to have the job description, but also make sure it's accurate and enforce it. Now, the other requirement, in addition to not discriminating against disabled people, is that you have to accommodate a disability when that person does have the disability. Well, what's an accommodation? The employee has to request it, but if it appears to you that your employee is disabled, then you need to engage in what the courts call an interactive process. That is, you need to talk to the employee about what are we going to do about this disability. And then we come up with what's the reasonable accommodation. The burden is on the employer to come up with the accommodation. And the burden is on, if the employer is going to deny the accommodation, the employer has to prove that the accommodation would be an undue burden on the employer's operation, either in terms of expense or in terms of other disruption of the work environment. One area that we know the courts have been pretty strict about is that allowing somebody to work from home when folks in that workplace are not traditionally working from home is not a reasonable accommodation that we have to meet. Your more classic accommodations would be the sight-impaired employee who needs the bigger computer screen, the sheriff's dispatcher who has a hearing problem but can be helped with a better headset that will allow him or her to hear properly, the employee who has to lift 50-pound drums of oil and could do that if they had a forklift or some other kind of a device that would help them lift that. So it's our obligation under the ADA to consider those and to implement them if those accommodations are reasonable. The next law, get back to Gramps here, is the Age Discrimination in Employment Act. This forbids us from discriminating against employees based on age. Under the statute, the presumed protected class is people older than 40. Those are considered to be older workers. But even if both of the workers are over 40, then you can still be guilty of discriminating on the basis of age or ageism by discriminating against one of them in favor of the other. The courts, they won't put this in stone, but there's a lot of cases that say that if the age difference is more than 10 years, then that's going to give rise to a presumption that age could have been a factor in discriminating against these folks, in discriminating against the older folk. This does not forbid an employer from considering factors that merely correlate to age. For example, if you decide to let one employee go because that person has a much higher salary based on having worked in our county for many years, and you've got a budget issue, then it's okay to say, I'm going to terminate the older employee, not because he's older, but because that will have the best budget impact. But boy, you better make sure you've got a good paper trail on that, that is the reason, and that you can defend it in court, that was the reason you terminated this person, not because they were the older person. Couple red flags here. One is never, ever, 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 even if you thought somebody else initiated the conversation, never ask an employee when he or she plans to retire. That will always get twisted into they were looking for a way to get rid of me, okay? Even if the employee comes up to you and says, gosh, I'm thinking about retiring, and you say, well, when are you thinking about retiring? In the complaint that gets filed later, that employee is going to say, they asked me about retirement, okay? Very frustrating, but be careful about that one. Another issue that comes up in workplaces a lot is cross-training. We often get cases where an employee has been cross-trained and later believes that they were being told to train the younger people who were going to take their place. Cross-training is a good thing, but don't use it as a way to then move the older employee out. The FMLA is very complicated. I hope your county handbooks have a good section on the FMLA. There are choices that counties have to make in terms of it. I just want to give you sort of the outline of it. The FMLA requires an employee to provide up to 12 weeks of leave, paid or unpaid, for an employee's own illness, the birth or adoption of a child, or to care for a seriously ill child, spouse, or parent. And then there are also provisions about caring for an injured service member. The leave can be continuous, week after week after week, or it can be intermittent. For example, in a case we had, you might have an employee whose husband is getting radiation treatments every other week, and so she has to take Thursday and Friday off on those weeks to help him. So then you count that against that 12 weeks. The employee does have to request the leave, but it's always a good idea that if you see an employee who's in a situation where he or she may need to know about FMLA or may need to consider it, that you go ahead and say to that employee, hey, we've got this FMLA policy. I want you to take a look at it and see whether that's something that would help you out under these circumstances. And then after the leave has occurred, the employee must be given the same or a substantially similar position when he or she returns. Okay. I was trying to remember if there's anything else I want to say about. Oh, so there's 12 weeks. The employer has multiple ways to calculate that 12 weeks. You can do it on a calendar year basis, you can do it on a fiscal year basis, or what many employers do is on a rolling basis. That is, that when the employee first asks for the FMLA, that's when that employee's 12 weeks starts running, is up through the 365 days after that. Your handbook should say what you've chosen, but it might be a good idea to go back and look at it and see if that's really the way you want it to work, and think about what the alternatives might look like in your county. Yes?
You say the employee must request the leave, but as the employer, don't we have the authority to designate the leave in the event an employee comes and is going to have surgery next week? Then I notify them that they have rights under Family and Medical Leave Act.
Correct.
And give them the certification form. Do I, as the employer, have the right to designate that leave as your family and medical leave, even though you have 4 weeks of vacation and 6 weeks of sick time that I really want to use first, and then I'll talk to you about family and medical leave?
Yes, but with proper notice to the employee. Is that right, Kent?
I can designate that.
You can designate that. Is that what you tell your clients? That yes, you can say this is family and medical leave, and we're counting that against your 12 weeks.
Serious health condition.
Yeah. Good question.
One thing is that if you have a policy, it's in your policy, that you must use must burn through.
They have to burn their paid leave.
Art, could you repeat the question for the video?
Yeah, the question here is that you can have a policy that says that even if you take the FMLA leave, you also have to use your paid leave during that period of time. All right, this is where Kent's going to talk a little bit more after the break, but I do want to make you aware of some issues here. The Fair Labor Standards Act is the act, the federal law, that most familiarly requires that we pay overtime for over 40 hours, time and a half for that, and has the minimum wage provision in it that we all have to follow. And then here's the problem, and again, I'll let Ken talk about this, but in late 2016, the Labor Department proposed to change the rules about who is an exempt and who's a non-exempt employee under the FLSA, including increasing the salary for a non-exempt employee, or for an exempt employee, to $47,476 with inflation adjustments into the future. That was challenged in court, and literally a week or two before this policy was supposed to go into effect, and after many, many employers around the country had already adjusted their job descriptions and pay levels to accommodate for this new rule going into effect, a federal court in Texas granted a preliminary injunction and stayed the rule. So that kind of threw everybody into a tizzy, and we're still in a tizzy. We still don't know what the status of that rule is. Are you going to talk about that, Kent? Okay, so Kent will talk about that, but I just want to let you know from a legal point of view, that's still up in the air. It's pending in an appellate court. The new administration is raising questions about whether they're going to continue with the rule as it was originally drafted. But here's the other thing I want to tell you that's extremely important from my point of view, which is the FLSA includes a record-keeping requirement, keeping record of your employees' hours and time. You might get an FLSA lawsuit where it turns out that you paid the employee everything that he or she was due, but the Labor Department is still going to come down on you for not having good record keeping. Here's where I found this in my practice to come up most frequently. You might have employees who occasionally work extra hours and nobody really keeps track of that. The case that I had that I always think of when this comes up is a case where a utility department had this issue of these pumps that kept going out at people's sewage hookups. And so the employees, somebody would be on call and they would have to run out in the middle of the night and check that pump and fix it or do whatever they needed to do. Nobody kept track of those hours, and then later when those employees were disciplined, they came back, and in addition to their suit for not being properly disciplined or for being discharged, they said, we also are owed all this back pay. And the client said, well, we don't have records of any of those overtime hours and the hours that those guys were going out. Guess who had the records? The guys had the records. They had their notebook where they'd been writing down every time that they'd run out. Had they been reporting those hours to their employer? No. Did the employer know that they were running out and checking those valves or whatever they were? Yes. Is the employer at risk then? Yes, not only for poor record keeping, but also for now not being able to prove in court that these employees didn't work those hours. Another situation that arose in a case that we had in the office, and this may come up in your workplaces, but it comes up, I think, probably pretty frequently. We had an elected official's office where everyone was given a half-hour lunch break, and what the employees generally did was they went to a back room and had their lunch. Well, when the phone rang, the employees would go and answer the phone. Or if somebody came up to the counter, some employee would stop at her lunch break and go and check. And for years that worked great. But when one of those employees ended up getting terminated for some misconduct, one of the things that she did was come back and say, oh, by the way, I have all these hours of overtime that I'd been working and never got compensated for because I was working. The hardest place for you to have to deal with this is the best employee in the world. Who's the best employee in the world? The one who says, I'll stay after for an hour to finish this report that's due tomorrow. The one that says, I'll go ahead and talk to this lady at the counter even though it's past our closing time, and then I'll go home. The problem with the best employee in the world is that you're not paying that employee for what he or she is doing. And if you don't enforce hours with respect to that employee, then you can't also enforce the hours with respect to other employees. So it's hard, but the consequence of not enforcing your hours is that you might be subject to a Fair Labor Standards Act suit later on down the line. Now, all of these statutes have a separate provision in them that forbids retaliation. What's retaliation? Retaliation is that if you engage in conduct or make a complaint under this statute, even if the complaint turns out not to be valid, you cannot be retaliated against for having made the complaint in the first place. So, the situation where this might come up is you've got an employee who's made a complaint, and then other people give that employee the cold shoulder. Or you decide this employee is a troublemaker for having made a complaint, and we're not going to promote that employee next time. I can't tell you how many times I've heard a client say, I'm not going to promote that person. That's somebody who sued the county. Why would I promote somebody who sued the county? Wrong thing to say, because if you are in a situation where an employee has raised their rights or another employee's rights under one of these statutes, then you need to treat that employee with equanimity, because then they might say you were retaliating against them. So I have a classic situation where this can come up. It's a catch-22, but I want you to be thinking about it. You've got an employee who for a year has been underperforming. Mistakes in the reports, not getting the reports done on time, poor relationship with the clients who come into the counter. And you've talked to this employee multiple times about your job performance is terrible, we need to improve it. You put the employee, you said, listen, if you can get your reports done better over the next 6 months, then we'll be fine. The reports just get worse. And finally, you decide there's nothing you can do but let this employee go. So on Monday, you say to the employee, I'm going to need you to meet with me in my office at 4 o'clock on Friday. Why 4 o'clock on Friday? Because in my experience, that's when everyone in government gets fired, is at 4 o'clock on Friday. So the employee says, fine. So on Thursday, at the end of the day, you're thinking, boy, this is going to be hard, but I'm going to have to fire this employee tomorrow. And then you hear, of course, this is getting old now, you hear the fax machine whirring in the background. Does anybody still have fax machines? I don't know. But you hear the fax machine. And you go to the fax machine, you pull out this 6-page document, and it says, FMLA medical certification, application for FMLA. Some doctor has signed this and has said this person has a serious medical condition. What is it? It's anxiety and depression. Why are they anxious and depressed? Because they're getting fired tomorrow. That's why. And then the doctor puts on there, how long is this condition expected to last? What does it always say? 12 weeks. Why? Because somehow the doctors know that 12 weeks is what the FMLA requires. So what do? You go through and have the termination meeting tomorrow? What's that going to look like? That's going to look like you got the FMLA certification and request on Thursday, and you fired the employee on Friday. That's always going to look like you were retaliating. So how do you get out of that box? How do you get out of the box? Well, here's how you maybe don't get completely out of the box, but you try to prevent this from happening. During that year that the employee's performance was so poor, you didn't document it. You didn't make a paper trail of what this employee's performance was like over that year. You didn't make any kind of a record that if your reports don't get submitted on time, we'll have no choice but to terminate you. You also didn't tell other folks on Monday, can you meet with me also on Friday because I'm planning to terminate this employee. And make a paper trail too as soon as you make that decision that this is where this was headed, so that later on in court you will be able to say, well, the FMLA had nothing to do with that. Here's this paper trail that shows why I was planning to terminate this employee on Friday. I'm not saying that'll avoid the lawsuit, but boy, it'll make it a lot easier to defend and make it a lot harder for this employee to put you into that catch-22 by suddenly putting up something that prevents you from retaliating against that employee. All right, I'll talk, let's see, we have a little bit of time before the break. We'll talk about Indiana statutes. There is an Indiana Civil Rights Act in addition to Title VII. This applies to employers, I think, of more than 6, who have more than 6 employees. It's enforced by the Indiana Civil Rights Commission. This has been in the news a lot here in central Indiana because there's been some complaints that this statute doesn't adequately protect women in particular, but other classifications from violations of their civil rights and discrimination. And as I said earlier, if you get a piece of paper that says Indiana Civil Rights Commission, we're investigating and asking you some questions, treat that as the prelude to a lawsuit, and do not answer it without bringing it to an attorney to review and decide how are we going to respond to this formally. Indiana also has its own version of the Fair Labor Standards Act. Indiana has its own minimum wage law, and Indiana has a couple of statutes that are traps sometimes for employers in terms of paying your employees in a timely fashion and making sure that when your employee is separated from employment that they've been paid for all back overtime and vacation leave and sick leave. Because if they are not, then they can sue you not only for that, but for triple that amount plus attorney fees. And we get that count thrown into many of these other lawsuits that an employee says, oh, wait a minute, you didn't pay me for a couple of weeks of vacation leave. A couple other statutes that we have to be aware of. There's a statute that's been on the books for a long time. We don't see it raised very often, but there's a statute that says that if the employee requests the reasons for their termination, that you have to give them the reasons in writing. Usually with an at-will employee in a termination meeting, you might or might not say, we're terminating you for specified reasons, but this statute is out there that says that you have to give them the reasons in writing if they request it. That's a time to review those reasons with an attorney to make sure that those reasons are well stated and comprehensive so that if later you're in court or in an unemployment compensation situation, that you are able to defend those reasons based on what you wrote at the time rather than making stuff up. There's a statute that says you cannot ask a prospective employee about expunged convictions. You can ask them about convictions, and generally you do that through your application. But there's a statute that says if the convictions have been expunged from the record, you can't ask them about that. And as I'm sure you're all familiar, there's a statute that says you cannot prohibit an employee from having firearms that are locked in private vehicles, even if that's in the workplace. Tort claims come up occasionally. I will review them very briefly. A tort is a personal injury. We do have a tort in this state of wrongful retaliatory discharge, wrongful discharge. That's a tort claim. That right now is limited to a couple of situations. One is if you terminate somebody for having exercised their right to workers' compensation. We call that a Frampton claim. That can be the basis for a tort claim of wrongful discharge. Another one is that if you terminate an employee because the employee refused to commit an illegal act, then that can be deemed an unlawful retaliatory discharge. I think that was a case where a truck driver said, I'm not driving that overloaded truck it exceeds the weight limit. And that person was terminated and then later brought a successful retaliatory discharge suit. Then there are other intentional torts, such as battery, defamation, and infliction of emotional distress. These will arise in the harassment context, but sometimes we have an issue of bullying in the workplace, and we've had a couple of plaintiffs' attorneys in Indiana who have brought claims of emotional distress, tortious emotional distress, based on the fact that somebody was subject to bullying by a supervisor. As near as I can tell, there's no separate tort of bullying, but if there is a problem with bullying, it's the notion that one person is subjecting another one to emotional distress. And then negligence comes up in the workplace because we can be found liable for negligently retaining or negligently hiring an employee, even though we were aware that that employee had a background of misconduct, or an employee had a history with us of misconduct. So if you have an employee who has a history of abusing customers or abusing people, then you need to be very careful about keeping that employee on, because you might, if that person does it again, the second bite, then you might be liable for having negligently retained that person. The Tort Claims Act only allows suit against the governmental entity. It requires notice to the governmental entity 180 days after the injury occurs. So again, if you get some kind of a written tort claim notice, that's something that needs to be passed on to your insurance company and to your attorney. And as long as you were acting within the scope of your employment, they can't sue you individually for that tort. And the damages are limited to $700,000 per individual. Hopefully you won't get into a case that involves that, and you cannot get punitive damages under the Tort Claims Act. All right, so I'd like to talk now about ways that we can minimize risk. And since you guys have this all printed out, I can push these buttons, but you know what they are in advance. One is to adopt clear written policies and job descriptions. It's frequently a problem in public workplaces, but I think probably in all workplaces, that people don't have written policies as to what the rules are. And once they write them down, nobody really knows that they're there. Oh, really? I can't tell you how many times we've been in a deposition and somebody's looked at a policy and said, well, I never saw this before. Where did this come from? Really? We were supposed to be here till 4:30 every day? I was supposed to show up at 8? That was never written down everywhere. It was just somebody told me when to show up, but nobody enforced it. And as I said before, job descriptions are really important too. Mostly for ADA reasons, but for other reasons. If you expect someone to adhere to the requirements of a job description, then write it down. But if you've written down a policy or you have a written policy, make sure it's followed. Make sure that you can later say, yes, we enforce this policy as to everybody. If the policy's wrong, then change it. If your policy in your office is to have some kind of a flex schedule where some people can come in at 8 and some people can come in at 8:15 and some people can come at 8:30, then change your policy to say that. Don't continue to operate under a policy that says all employees are expected to report to work at 8. If you haven't enforced that policy or it's not consistent, and then you want to terminate somebody for showing up late every time, the policy's not going to help you. Always respond promptly to complaints or grievances by your employees. You have an obligation to make sure that those employees' grievances are investigated and dealt with promptly. Always keep an eye out for behavior that might be considered harassing and address it immediately. Don't let it fester. Even a 3 or 4 week period of time in failing to address a situation can result in liability. Always ask yourself when you're taking an action against an employee, can I explain why I'm doing this without respect to this employee's religion, without respect to this employee's sex, without respect to the politics? Even write it down maybe for yourself to say, okay, logically, can I explain what the reasons are for this action without, and be able to defend it in a way that doesn't implicate these rights? Don't even joke about sex, race, religion in the workplace, even if you think the jokes are welcome. And here's where I think supervisors have a special duty to set an example for other people in the workplace. If you're telling the dirty jokes, then your employees are going to think that's okay. So that's very important to make sure that supervisors are setting an example for their employees of civil and professional conduct that won't subject you or the county to liability. Interviews. Good idea to always prepare your questions in advance and then ask the questions of each candidate so that you can say later, yes, I asked these questions, and then write down the responses. Now, I use the word record. We need to change that, Mark. I used the word record, and somebody said, oh, do you mean you need to audio record the interview? No, I don't mean that. But write down the responses so later, when somebody says they didn't hire me because I was blank, then you can go back and say, oh no, I noted in my interview questions that this person's education was lacking in this area or their experience was lacking in a particular area, and you can go back and say, I made a written record of why it is that this person didn't meet those requirements. Always avoid questions about arrests or expunged convictions, physical or emotional disabilities. I notice you have a limp, bad question. Family, ethnicity, is it okay with your, have you talked to your husband about whether you'll be able to work outside the home? Age, this is where, when do you plan to retire? We did have a case where a county commissioner was alleged to have said during an oral interview, how long do you plan to continue working? And that was taken as age discrimination. And the commissioner didn't think he asked the question exactly that way, but it was close enough to the truth that we were concerned that he had said something to this older person who was applying for the job, implying that, well, if we hire you, you're only going to work for 2 or 3 years because you're too old. And of course, avoid in an interview any kind of questions about political activities or support, unless of course it's an interview that you are confident is for a position, an appointed position that's not protected by the First Amendment. If you do performance evaluations, they can be a very valuable tool for supervising employees. But if you do them, take them seriously or don't do them at all. We often would run into situations where we would be told, well, this person who's suing us, they were a terrible employee. They never got their reports done on time. There were all these issues with them. They'd show up late to work. And then you'd open the personnel file and you'd find a performance evaluation that would give them A+ on every category. Well, what's up with that? Well, I think what's up with that, and I've been there, is that it's hard to tell people that they're not doing a good job. It's hard to criticize people. But if you're going to do these performance evaluations, do them honestly. Always give the employee an opportunity to respond, including in writing. And don't exaggerate either on the plus side or the negative side. Okay. Issue for liability and defending lawsuits, emails. You probably have gotten this already hammered away by the public access counselor and other people, but I'm going to repeat it here. Emails are public documents. Emails about government business are public documents, even if you sent them on your personal cell phone, even if you texted them on your personal cell phone. Emails of any kind, communications about government business, are covered by the Indiana Access to Public Records Law, and they are public documents. And if you are sued, the other side will get them and see them and read them. So, always a good idea in your government-related emails to avoid informal style, avoid joking, avoid emojis, which look unprofessional and can communicate the wrong thing. We had a case a couple years ago where an excellent jail commander was writing an email to the nurse at the jail, and this inmate had come to him and wanted to be taken to the hospital. And he had explained to him, no, we're not going to take you to the hospital until the medical people say you have to go to the hospital. And he said, and I told him, this is not like being out, you're in jail. LOL. LOL? What's that doing in there? Well, I understand the context is he's writing to a nurse who's a friend of his, and they're kind of chuckling over the fact that this inmate thinks he can be taken to the hospital at the drop of a hat. But what's that going to look like to the jury that's assessing whether these people were indifferent to this inmate's medical care? It's going to look like they were laughing and joking about it. And I use that not to make fun of the jail commander. I certainly understood where he was coming from on this case, and I don't think he was being indifferent. But it's just an example of how putting a little tag in an email like that can completely change the tone of it if someone else is reading it. I love trees, I love the environment, but I can't tell you how many times that we would say, well, where's the paper trail? Well, it's in all these emails. Where are the emails? They're on my computer. Show me. Wait a minute, they're not there. Let's talk to IT. What does IT say? Remember when we switched over the server and we put all that data on another server that now we can't figure out how to get it? Blah, blah, blah. You guys have probably heard that too. If you are keeping a paper trail by email or on a computer, print it. Print it. Forget the trees. Because it will, if you didn't print it, we won't be able to find it later. All right, and then this is funny if you don't have the printout here. But the overall 3 tips are to document, document, and document. It's supposed to be funny. It just happens all the time in litigation that people say, well, I had this conversation with them and they told me this. Or we talked about it, and then what you've got is a swearing contest because the other person's going to say, no, I heard it differently. I didn't say that. So it's always important if you're in any kind of a situation you think that's possibly going to evolve into litigation or some kind of personnel action, to document it. The piece of paper that says, we had this conversation today, you said this, I said that, is always going to be more persuasive in court than you saying under oath, I said this and he said that. So with that, that's the conclusion of our presentation. And we got just 5 minutes. Any questions before the break? Yes, ma'am.
You were speaking of FMLA and time paid. So I have an FMLA actual clock that I send to the department heads. It's all
They start when they go into the surgery. This is a question we got earlier. You can start that FMLA clock when they have the serious medical condition and count that, but you have to give them notice that you're doing it.
Did they ask for the paperwork or after we get it from the doctor and stuff?
You can send them the paperwork first when you know this is coming up. If it's a surgery situation, send them the paperwork and give them notice that you are going to consider this FMLA time.
Okay.
And then what's the standing on if an employee has an emergent condition, they end up ambulance ride in the hospital and, you know, heart surgery, you have the right to start it for them
Yes,
at that point?
you do, but as soon as it becomes practical, you need to give them notice that you did that.
Right.
Okay. I had a situation, you're reminding me of a terrible situation I had where an employee had attempted suicide. And the HR person, as soon as that person became conscious again and was in the hospital, they woke up and there's the HR person at their bedside with the certification form saying, this is going to be FMLA time. Not good. Not a good way to handle that. But that was an aggressive HR person who was making sure that that person got notice that their time was going to be considered to be FMLA time. So
You should at least bring flowers.
flowers would have been nice.